Hello, my name is Logan Amick, and for this week's video assignment, I will be providing an overview of the paper regarding the car sale between Bob Jones and Johnny Jett. Two, I'll detail whether there's a proper merchant agreement, including an offer, acceptance, and consideration for a UCC sales contract between Johnny Jett Auto Resale Specialist and Bob Jones Auto Sales. Three, I'll also determine whether the goods have been identified in the contract document and whether the title was valid when passed between Bob Jones Auto Sales and Johnny Jett Auto Resale Specialist. I'll also provide and support citing facts that apply to the law relevant to my argument. And then four, I will also note any warranties that apply to the auto sales contract based on the facts of the language of the contract. So, number one, the facts in the case of Bob Jones and Johnny Jett are Johnny just got his driver's license and wanted to buy a car. He didn't tell his parents he was taking his driver's test or that he wanted to buy a car. And so he worked on his father's farm and saved $5,000 that he had planned to use for his new car. He had been talking to Bob Jones, who owned the car dealership in another town close to Johnny's. Johnny has significant health issues, which caused him not to be able to visit his friends out of area. So Johnny's parents didn't know that he had been talking to Bob and probably wouldn't have given him permission to buy a car for himself. But Johnny didn't tell Bob how old he was or that he had health issues. But Bob didn't ask him either. So, Bob shows Johnny a 2005 Mustang. Tells him that it's the best car in the county, and it only had 25,000 miles on it. He also told him that it only had one owner and has never been in an accident. So the sale price was $4,999. But Bob said he would sell it to Johnny for $4,500. So Johnny told Bob that he was going to use the car to transport moonshine. Sorry. It was at this point that Bob noticed that Johnny isn't really understanding what he is being told. Bob also recalls remembering hearing that Johnny may have health issues, but doesn't really follow up or ask any questions really. So Johnny goes ahead and accepts the sale price of the $4,500 to buy the car with cash. And Bob tells Johnny that the car is being sold as is, where is, which means that he agrees to whatever shape the car is in, and he's agreeing to take it anyway. So Johnny goes ahead and drives the car home. He's excited, tells his parents about the purchase, but his parents aren't happy about his decision. Johnny's mom researches the vehicle, finds out the car had, multiple owners. It's been in multiple car accidents. It had a flood, none of which Bob told Johnny at the time of the sale. In fact, Bob lied and said the car only had one owner and never had been in an accident. So, the mileage didn't match up what was online either. So it can mean that someone turned back the odometer to make it look like it had less miles than it actually did. Johnny's parents were scheduled to go out of town the next day. They couldn't address the issue with Bob until they returned. When they got back, they went to Bob and asked to return the car and get their money back, but Bob ended up refusing, stating that Johnny bought the car as is, where is. So, going on to question 2. Under the UCC Article 2 in the state of Nebraska, this sale between merchants, which is Johnny Jett Auto Resale Specialist and Bob Jones Auto Sales, having a bill of sale to motor vehicles show that there was a proper offer, even though Bob lied in his offer to Johnny. Under the UCC Article 2, if either or both parties have not thoroughly addressed issues in the written contract, the UCC Article 2 protects them from requesting damages. Also, the written bill of sale states that the vehicle was sold as is where is, which means that Johnney agreed to purchase the vehicle no matter what condition it was, and he couldn't request damages from Bob because he gave him up he gave that up in the contract. So there was acceptance by Johnney. He agreed to buy the vehicle in the condition that it was in, for the price that was being offered, and Bob agreed to accept money for the sale of the vehicle. So consideration of the UCC contract is valid due to the fact that Johnney and Bob were merchants and are considered to have knowledge of those goods being sold. So number 3, the goods were clearly identified in the contract, which included vehicle identification number, odometer readings, year, make, model. However, there was no mention of a title that was validly passed from Bob to Johnney. So in the state of Nebraska, a vehicle cannot have a transfer of ownership without a certificate of title showing the person who sold the vehicle to the new owner. So technically, Johnney bought a car that he didn't even have legal ownership of. So moving on to number 4, the bill of sale clearly states that the seller, which is Bob, expressly disclaims all warranties, expressed or implied, including but not limited to any implied warranty of merchantability. It also states that the seller disclaims warranty as to the condition of the working order of the vehicle. So by signing that contract, Johnney agreed that the vehicle will not only be purchased as is, where is, but he understood that there was no warranty of any kind attached to the vehicle. Thank you.